warmest of welcomes to this important webinar hosted by LexisNexis South Africa in association with the Legal Practice Council. I'm Jeremy Maggs. Now, let me give you some background here. Today, we are standing on the cusp of important significant changes within the legal landscape of the country. The recent proposals by the Legal Practice Council of South Africa promise to shape the future of the legal fraternity, and I'm sensing that the intention here is to drive towards a more inclusive, equitable, and just legal system. So as we dive into these proposed changes, it's essential for every legal practitioner to understand and adapt, ensuring that the profession upholds the integrity of its operating environment and serves its community effectively. And I have a special guest with me today. Brian Mhlongo is an admitted attorney of the High Court and currently a senior legal advisor at the Legal Practice Council. Importantly, Brian has or says he strongly believes in the need for a minimum wage for candidate legal practitioners in the country. Before we get to that, and I'm really looking forward to this conversation, let me just allow myself very briefly to introduce an online solution for your legal legislative needs. I want to talk very quickly about Lexis Library. It's an online resource that makes it easier for practitioners to stay ahead of legal amendments with our ever-evolving law, such as what we're going to talk about now. With updated legislation and case precedent, this tool is the one that you need to lighten your load. No more daunting research hours, no more falling behind on evolving legislation, or with Lexis Library. Before Brian starts talking, I'm just going to ask you, as we always do at the start of these webinar sessions, is to complete the poll that has just popped up on your screen so that a consultant can get in touch with you. So having got all of that out the way, the introduction and details on Lexis Library, Brian, the very warmest of welcomes to you, and I'm looking forward to this conversation. Maybe before we start looking at hours and wages and all of that kind of thing, just give me a brief indication of what the Legal Practice Council is and what the broad remit involves.
Thank you so much, Jeremy. Thank you so much to everyone, and also to be given the opportunity to speak today. The Legal Practice Council, generally, I would like to just give a brief background that it is the common cause that prior to its establishment, each province in South Africa had its own regulatory body, which was known as the Provincial Law Societies. These societies were responsible for regulating attorneys and advocates within their respective provinces. But however, there was a need for the establishment of the Legal Practice Council to create a single unified statutory body that will regulate all legal practitioners. And that's when the Legal Practice Council, or why the Legal Practice Council was established. The Legal Practice Council is a statutory body established in terms of Section 4 of the Legal Practice Act. And the council, it provides norms and standards for legal practitioners in which they need to adhere to in their daily lives of practice. And it also provides guidelines and frameworks for legal practitioners for their admissions and enrollment into the profession. And it also creates or promotes the development of candidate legal practitioners and legal practitioners alike. And the Act came into effect in November 2018, and that's when we fully converted from the old law societies and we became the Legal Practice Council. And its objectives of the council are stated in Section 5 of the Legal Practice Act, which also includes what we'll be talking about today.
That's very useful and important background, and it also tells me that you speak with not only authority, but also breadth as far as the profession is concerned. So let's get into the nub of our conversation today then, Brian. We have key amendments, proposed amendments to the Legal Practice Act. Before we talk about what the key amendments are. Why is the need to change? What is driving that?
Jeremy, thank you for that question. Especially when it comes to the minimum wages, it's actually regulated by the act that we must, the Legal Practice Council must set minimum wages or remunerations or allowances for candidate legal practitioners. In terms of section 27 of the Act, subsection 2 of it stipulates that the council must regulate and determine the allowances or minimum wages that must be provided to candidate legal practitioners. So at present, that's why there's the confusion maybe amongst legal practitioners to maybe think that we are increasing something that was already there, but there was no, at present, there's no set minimum wages determined for candidate legal practitioners. So legal practitioners at the moment, they're at liberty to determine how a candidate legal practitioner must earn or what they must earn. Ever since the Attorneys Act was repealed, when the Legal Practice Act came into effect, there hasn't been any set minimum wages. So that's why the drive today, or ever since we started with the implementation or the proposing the minimum wages that we've actually gazetted on the 11th of August 2023. So previously, in terms of the Attorneys Act, in terms of Section 8, subsection 2 of that Act, that was the last time they set the minimum wage, which was 50 rands at that time. So ever since then, there hasn't been any minimum wages that were set, and we only started setting them or proposing them last year when we sent out a survey to legal practitioners and candidate legal practitioners to comment on on what they actually provide to candidate attorneys, so we can just determine. That's when actually everything started rolling out and playing to what you are now seeing today.
I'm just shaking my head at that figure of 50 rand, and
yeah.
and it just tells me how important it is for some sort of change to be implemented. I want to ask you a two-sided question.
Yes.
One is, how much pressure is being applied to examine this issue? And then the other side of the question is, how much support and pushback is there? Let's start with the pressure. Is there pressure to change, and where is the pressure coming
from? The pressure is from the Act itself, since it came into effect. The Legal Practice Council, or the council itself, it's obligated to implement all the objectives that are governed by the Act. So Section 27 is also one of those obligations that are being placed upon the council, that they need to determine a fee for candidate legal practitioners. And there's also the need for it, if you notice in the public how most of the candidate legal practitioners have been having issues with regards to some even working for free just to get their articles, and some not even being paid. Some are even being paid below the minimum wage that has been implemented even now in 2019. So that also made the council feel that there's a need to really help or assist candidate attorneys to get the bare minimum to be able to fully train and get the experience that they require, because they are also technically generating or providing services for the firms that they work in. So it would be prudent or fair for them to also be given some form of remuneration to be able to live up to the standard of a legal practitioner himself, because they are required to be wearing suits in a certain way, robes when they appear in court, and all of those things require some form of little bit of stipend or remuneration for them to be able to meet those standards.
Mm.
Yes.
Thanks for telling me about the suit, Brian. Had you told me that before we started this webinar, I would have put a suit and tie on. But
That's okay.
aside from that, though, I suppose there's that old adage that a fair wage guarantees better work.
Yes.
So it makes perfect sense. Before we get to the numbers themselves, does this have widespread support within the legal fraternity, or is there some pushback?
There has been, with regards to because we did send out surveys to candidate legal practitioners and also the legal practitioners who are principals, and requested their comments with regards to, even before we published the notice in the Government Gazette, we sent out the surveys in August and in October in 2022, but we didn't receive like a lot of feedback as we expected. The numbers of the response were a little bit poor, but we managed to notice that there is some resistance from other legal practitioners, and they were stating that, for instance, they cannot afford to pay any other amount than the one that they're already paying. And that also caused a little bit of frustration on the part of the council, but the council does understand, since we just came back from the COVID era, and a lot has happened there, which has made it hard for the legal profession itself in the past 2 years, and some are actually still recovering. That's why in the surveys and even in the advisory that was sent after the survey, the LPC expressed that they do note the concerns, and this is still a work in progress, and that's why we need legal practitioners to comment on and put on their views for the council to consider before implementing the minimum wage. So we have been receiving a little bit of pushback, but more particularly on the advocate side, because it is also common cause that pupils who shadow advocates are technically not employees of those advocates. So it becomes a tough thing for an advocate to now just say, I'm remunerating the pupil. And again, the dynamics are quite different there, because they technically also don't generate fees for the advocates. So that's where the difficulty is for the council. But even though they also don't generate fees, but they are still training to become advocates, and it's really they also need some form of stipend to do the legal research, to prepare and assist their supervisor while they are under their PVT. So they do also need some form of stipend, because Jeremy, we're talking about someone who just came out of varsity with all we wouldn't know, especially people from disadvantaged backgrounds, with all the loans and school things to pay for their academics, and then they still get to spend a whole year being supervised and not earning any income with some advocates. So it's really a hard thing, or a hard pill to swallow, actually. But yeah, we have been receiving some of the resistance there, but not much, because the minimum, the proposed amendments that we took out in 11 August, the closing date was 11 September. And we compiled some of the comments, although I can't disclose anything now, as the council hasn't had the opportunity to go through them. But we have been seeing a lot of positive feedback with regards to what we are trying to do now.
Could you explain to me the work that you've done in reaching what a fair and equitable minimum wage is? And are you able to disclose numbers?
What I can say is that during our survey, what we did was we first took it out to the legal practitioners to inform us what do they currently pay, what can they afford to pay, and what do they think is a reasonable amount to provide to a candidate attorney. And then we also looked at the current remunerations that are provided by law firms in this current days. And we noticed that there's too much discrepancies due to the fact that there's no set minimum wage. And some would also be looked at as the big firms would provide a lot of remuneration, or actually remuneration that would be enough for a candidate attorney to work and work efficiently. And then with the ones from disadvantaged areas or backgrounds, you find where they actually earn below even the set minimum wage, and some don't even earn anything. So when we did our research, we found all of those type of discrepancies. But since we didn't get enough comments with regards to our surveys, because we took them out more than once, the council then decided, no, I think we might get more comments if we put in the proposed amendment, the proposed minimum wages as they were presented on the 11th of August 2023. So the determining those figures was mostly due to what the current remuneration structure is with the law firms, from the ones from rural areas to the ones in the urban areas. And also they looked at the responses that we received from the surveys on what legal practitioners were comfortable in paying, and what they felt like now it's, for instance, a lot. So those figures were determined from the survey results that we received, plus the research that the council went through in just getting to those proposed figures.
Does the council have an official view on what constitutes a reasonable minimum wage?
At the moment, they don't. What the council thinks is more efficient at the moment, I would say it's the figures that we put through now, but they are all subject to change, which will be determined by the comments that we just received. Because also the council is also legal practitioners who also have law firms, and some are advocates who also practice as advocates out there. So they also have the field experience and know what is going on out there. And that's why it's easier for them, again, to determine or come up with what they think the profession would be comfortable with.
Are you able to disclose what type of numbers you're looking at now, or is it inopportune to raise that issue right now?
At the moment, I might get into trouble if maybe I disclose now. As I mentioned, that the closing date for the comments was only on the 11th of September, and we are having our professional affairs committee. Sorry, just to put some more context, the council has subcommittees that deal with different types of matters in accordance to the objectives of the council. So the minimum wages, the proposed minimum wages falls under the professional affairs committee. So the professional affairs committee is still members of the committee, of the council itself, and then they will be the ones that sit. Their next sitting is on the 5th of October 2023. That's when they will get to go through all the comments that we've received, and also consider whether what must happen, what should be the next step. Should we still engage the legal practitioners, or should we set the minimum wage as it is, or should we increase it? They will decide upon considering all the comments that we've received. And
the only point I can make, Brian, is that I'm assuming it's more than 50 Rand.
Yes, yes, it will definitely be more than 50 rand, hopefully.
I would sincerely hope so, Brian.
Yes.
I'm interested just to flesh out the role of this professional affairs committee, if we can. Could you explain to me what process it will go through and what criteria it will use in order to reach a fair and equitable decision?
Um, the first process or the step that they considered when they went through determining the minimum wage for candidate legal practitioners was to take out the survey and then request that research be done with regards to the work or the daily activities of a candidate legal practitioner. What are they expected to do so they can determine the service that they provide while they are under PVT. But although that one is hard because every firm, it depends on what the firm does, unless it's a big firm that actually covers most of the work that's normally legal services that are provided out there. But some smaller firms would maybe specialize in conveyancing only, or just a few more other legal services. So they looked at all of those type of issues in considering how much would be suitable for a candidate legal practitioner, and also compared it with what the Minimum Wage Act says or states with regards to what would be a reasonable minimum wage. Because currently with most candidate legal practitioners, some of them earn below even the minimum wage that's out there. And it's sad because they are already professionals, and that's one of the other things that the council considered.
Brian, you spoke a little earlier about the differential between rural and urban law firms. We all know in the South African legal environment that there are the big five or the big six or whatever law firms in this country. Would the Legal Practices Council also be looking at a sliding scale? So, for instance, there is affordability. There's perhaps greater affordability at a big law firm in central Johannesburg as opposed to a small law firm in Umtata, for instance.
Thank you, Jeremy, for that question. Yes, the council is actually even now considering those type of things in the background, and they will still take them into consideration. And as with regards to even advocates, the council already started with engaging with SASITA, the Safety and Security Sector Education Training Authority, and providing funding for pupils. And that has also helped a lot. Although, for instance, you cannot always outsource that part of responsibility. Also, as a profession, we need to also assist in also uplifting our own profession. So that's why we also requested that advocates must also consider in assisting in providing those stipends to advocates. So that will also, the council is also considering in extending that to candidate attorneys who for those law firms that would, for instance, inform us that they cannot afford the minimum wage that has been set, to just through SASITA also subsidize or assist in those measures. Although there's no defined structure at the moment, since this is still in the proposed stages, but those are things that the Professional Affairs Committee is already considering and is already engaging SASITA in such.
Brian, do you think the minimum wage proposal is going to have a positive impact on recruitment of candidate legal practitioners?
Yeah, with regards to that one, Jeremy, it is quite a complex issue there, because from just browsing through the comments that we've received so far, some law firms or legal practitioners are actually stating or expressing that the minimum wage, if it's implemented, it might affect their ability to take on candidate attorneys or more candidate attorneys. And the council itself even expressed that concern too, that setting the minimum wage, they are aware or they've noted that it might have that effect in the legal profession. But as I mentioned, that the council will also try and find other means to assist legal practitioners in terms of remunerating the candidate attorneys, like through SASITA. And with that, I think it might assist with those who are finding it hard to meet those minimum wages, maybe in a form of subsidizing, or they can inform us what they will be able to pay, and maybe SASITA will then assist, or the LPC through SASITA will then assist in covering that amount. But I'm not making any promise, but it's one of the things that the Professional Affairs Committee is considering or playing around with, to try and ensure that access to the profession is not affected or jeopardized.
I suppose, Brian, there's also a flip side to that argument, that if a positive minimum wage is implemented, it might encourage more people, quality people, into the profession who might have balked at it earlier because of how difficult it is in the foundation phase.
True, Jeremy. I agree with you there that it can work both ways, because now it's just fear of the unknown. I feel like sometimes once you see change, it would freak or make people feel uncomfortable and think it's something that that might affect the profession. But in a positive light, it will, like as you mentioned, it would bring more people, or make more people interested in joining the legal profession, and it will also uplift our profession as a whole. As normally when I was also growing up, the legal profession was also compared with the medical profession and the accounting profession. But in terms of remuneration from the onset, the scales are quite far apart. So to just try and get to a point where we uplift our profession, that would be an amazing achievement. And the journey starts now with us putting ourselves where we belong. Technically, that's what I would say. Because
no, I do understand the argument, and at the risk of alienating myself with candidate attorneys, I suppose the flip side of the argument is that in the beginning of a career, whether it's whether you're doing your housemanship as a doctor, whether you're a young auditor, or whether you are a candidate attorney, essentially you're an intern, and that the value is also derived from the experience that you're gaining and the wisdom that you are gleaning from people who are teaching you, and that's got to be factored in as well. So it can't be a completely easy ride, can it?
Yes. It's never easy. It's never easy. But we as attorneys that have already qualified, or as legal practitioners that are already out there, we should also try and uplift and enable the candidate legal practitioners to not to go through, for instance, us in the legal profession, what we went through at our time during our articles, where you end close to nothing, and you expected to still provide services to the law firms. And we should also not just take to granted the work that candidate legal practitioners do. They do a lot of work as candidate attorneys to also learn and acquire the skills. So there's a lot that goes to them being trained, and they go through a lot, and there's too much that's expected of them. And I think at the back of their minds, remuneration should be the last thing that they need to worry about. And we are not asking for them to be paid a lot of money, but we are asking for them to be paid enough for them to survive. As I mentioned, that with some candidate attorneys, they would be graduating from a university, for example, a university in Limpopo, and they come and work in Joburg, and that person needs to get accommodation. He needs to have enough clothes and proper clothes to attend court. They need to attend court. They need to have transport to drive to court, to go serve documents, to learn how all of those things are done. And with less to no salary, that becomes impossible, or it becomes hard for them. And thus, some of them end up dropping or looking for other jobs. And we are actually, I feel that's when we are blocking access to the profession, and we are not uplifting our own people who show that they are interested in joining the profession.
You make a fair point. And I mean, the justice system in South Africa requires the very best lawyers and the best trained lawyers. And point I made earlier, about a fair wage guarantees good work. You touched, Brian, on a little earlier on remuneration for pupil advocates, and the fact that they are not traditionally employed, I think was the phrase that you used. But the remuneration then between pupil advocates and their supervisors, is this a different stream? I think you refer to it as. How easier, or how much easier is it going to be to reach a resolution on that side, given that there are two distinct sides of the legal professional coin?
Thank you, Jeremy. Yeah, as I mentioned earlier, when it comes to pupils, that's where it becomes a little bit more complex, and it becomes more hard, that the fact that they are not employees of the supervisors or the advocates that have actually taken them on to mentor them to become advocates in the future. So that's
but they are part of an ecosystem.
Yes, they are part of the ecosystem. They are also regarded as candidate legal practitioners. It's a noble profession and a noble path to choose to become an advocate, which with some of the comments that we've been receiving is, although there's resistance, but with most of them, there's also it shows that the advocates are also willing to assist pupils in getting some form of stipend, because they understand the hardship and the work that goes into becoming an advocate, and the fact that they require research, they require a lot of tools to get to where they need to get to, which also needs money. So the only resistance we are receiving is the proposed contribution that we've mentioned there, that we will require a certain amount of money to be paid by the advocates, and that's where we got a little bit of resistance in. But I'm most definitely sure that when we deal with the comments as a whole with professional affairs committee, they'll be able to also go back and try and reach some form of conclusion or agreement with the advocate part of the profession, to see how much are they willing to contribute. Because already currently, as I mentioned, that the LPC has engaged with SASITA a few years back, and we have been providing pupils with stipends ever since then, and there hasn't been any issues with that. We just wanted to secure and ensure that pupils are also fairly remunerated, and we're not sure at what point are we still going to have the relationship with SASITA. So to secure, or for the advocates to also contribute, that would assist in making sure that pupils are always remunerated, and they have some form of stipend or income that's coming their way to assist them. And it will also enable more candidate legal practitioner or people who are interested in being advocates in joining that part or stream of the profession, which will help greatly in the profession itself. So, as you mentioned earlier, it can work in both ways. It can be a positive thing too.
Yeah. Brian, I'm wondering to myself whether the proposed changes, and I understand where we are with the process right now, have any basis of comparison similar practices globally? Has the LPC looked offshore to see if there is best practice?
It has, when it comes to the proposed remuneration, no, they haven't went globally to check there, because again, when we go globally, the rules and what governs the legal profession, it's different, and the manner in which some countries operate, it's not the same as how we do it. So, for instance, like in the US, it's determined, the profession is governed differently from how the LPC in South Africa it's done, because in South Africa it is the LPC that regulates the profession. That side, even the state gets involved in dealing with the profession. So we, even comparing the figures, it wouldn't have yield a positive result on our side.
I understand.
Yeah.
We don't need to spend any more time on that. So I just want to get a sense of timeline now, Brian, if I can. So you would be busy evaluating submissions. This would be the Professional Affairs Committee. Once there is some concordance which is reached in that respect, what's the progressional timeline going forward?
The council has honestly, they've been wanting to implement the minimum wages for a while. It's been something that they want to do. So even now, their wish was to implement it before even the year ends. So the following year, such things can start applying. But due to some of the comments, and especially when we issued the survey, which actually delayed it being implemented even this year, and us resulting in sending out the proposed amendments through the government gazette, just to get enough comments from the profession. I think after this, we will have to, once they've deliberated on it and reached a conclusion, I think we will communicate with the profession again and see their views on the final figures, for instance, that the council or the committee would have come up with or concluded on, and then see what their views are, and then we will then proceed to set those minimum wages as a final gazette. Before, in terms of timelines, most probably now it will be something that happens early next year. I don't think it will go past March or then without us having dealt with everything.
Brian, assuming that agreement is reached and there is implementation of change, I've got two questions then. How would the LPC support legal practitioners during what could be a tricky transition? And would there be mechanisms that you've designed that would be put in place to measure impact? Let's look at support first of all during the implementation phase. What would be the ask of you?
As I mentioned earlier, that even now in the background, the council is engaging with SASITA with regards to also assisting candidate attorneys with regards to funding. So that would also come into play now. After they've considered the comments, they'll also see where they can take it with SASITA and what proposals they can make and arrangements and create some form of like structure. As I mentioned, that maybe some attorneys may apply to the council and inform them that, for instance, this is what I make in I cannot afford to pay a candidate attorney this amount of money. What I've been affording to pay is, for instance, a 2,000 rand.
So some sort of independent arbitration process.
Yes, to try and assist in getting maybe some form of subsidy to be like, for instance, for the council to meet them halfway in what they can afford to pay. So maybe something like that will be in play with.
Fair enough. I fully acknowledge at this point that we are looking at, we were starting to go into the realm of speculation here, and I know that not all of this has been agreed to, but it's worth ventilating. The other thing, of course, is monitoring and compliance and making sure that there is guarantee of implementation, which is perhaps harder, isn't it?
Yes. It is a little bit hard, but as we are mandated by the Act and the rules that came through the Act, we are actually required to set the minimum wage. So that is something that the council will implement. Is just now we are trying to make sure that it doesn't sit or bring a distasteful taste on the legal practitioners.
No, you've got to be judicious about it. I understand that.
Yeah, where it ends up reducing the number of candidate attorneys taken into the profession, because we cannot block access to the profession. So a lot of consultation still needs to be done after going through the comments to ensure that none of that actually comes forth.
So that's one side of the process. The other side of the process, of course, is ours. And one of the issues that is being discussed is mandatory community service. Please fill me in on where we stand with that right now, and would it work in a similar way to the medical profession, for instance?
Oh, thank you, Jeremy. Yes, with regards to community service, the minister actually finally gazetted or promulgated the regulation for A and B, which is the ones that we will be using in dealing with community service or pro bono for the legal profession, which applies to practicing legal practitioners and candidate legal practitioners. With that one, at the moment, since there's no set structure on how we should or how practitioners will be sourcing such pro bono work or such community service, the council has decided in its last meeting a few weeks ago to only apply regulation 4A and B next year in January 2024, after they've actually developed structures and procedures and processes of how we will deal with the community service for the legal profession. Because with some big firms, some firms have their own pro bono or pro bono departments that actually deal with such matters. So there's a lot of confusion among the profession on how they should go about it, because now with the promulgated regulations, it means each individual or the legal practitioner must serve, for instance, the 40 hours that's mentioned in the regulations, and the candidate attorney must do at least the 8 hours. So there's been a lot of confusion on how they will source that. And with regards, we've also been receiving the comments or the concerns from big firms that already have those departments that deal with pro bono work. So they've been asking, how is the council going to deal with such issues? Thus, the council decided, no, it must be put on hold, and they must develop structures which will be sent to the legal profession soon for their comments before we apply regulation for A and B.
So, Brian, issues like hours of community service and structures in place to monitor and ensure the effective implementation. That's you're saying it will be discussed, but there's nothing finite on the table as yet.
Yes, it will be discussed, because even the council has come to a conclusion that they might need within the council, we might need more staff to actually monitor those applications. As you noticed on the regulations, there's forms that candidate attorneys and attorneys will have to fill, and they'll be signed and be submitted to the council. So there still needs to be some form of procedure or process that's efficient, that will be able to capture the information that's being provided by the legal practitioners on the community work that they've done. And now having to move with the times, it might have to be a digital thing that where legal practitioners actually do it themselves, and it automatically updates on their profile or on their on their profile with the LPC, where the numbers will start showing automatically. So it's something that also, again, it falls within the Professional Affairs Committee. So it's something that they are also now engaging on trying to see how is the council going to be able to make sure that the process moves swiftly and smoothly, and that legal practitioners and candidate legal practitioners don't struggle in obtaining the access to assist people via pro bono and actually doing the community service work.
Remind me, Brian, of the benefits and the objectives of community service.
As the Legal Practice Act, actually, it's now it promotes transformation and protection. It promotes transformation and access to the profession, and also access to justice for members of the public. So the implementation of the community service will promote access to justice for those underprivileged people who cannot afford an attorney, but then will get the benefit of being assisted without having to pay anything or have to worry about funds. So it will promote access to justice, and they will be getting good services from good legal practitioners to aid and assist them, because most of them suffer even with road accident fund matters, where they wouldn't know where to go, they wouldn't know how to get access to an attorney. And with such with these regulations, they will be able to get that assistance. And it doesn't only assist, for instance, members of the public, but also assist candidate attorneys in getting the experience and the exposure in some other matters, and also reaching out as a profession as a whole, being candidate attorneys and attorneys, in uplifting our communities and also assisting the public in growing the profession as a whole.
Brian, as we come to the end of this conversation, I've got two more questions to ask you. One is, we've spoken about the hours and we've spoken about minimum wage. Is there any role that legal educational institutions, in other words, the law schools, can play in supporting these changes? And is that already happening?
That is it's already happening. Members of the council, some of them are also members of in some of these law societies. They participate in that, and also teaching prominent candidate attorneys. And what the law schools would do is they always provide information relating to what the council is currently doing, and providing or teaching or candidate legal practitioners in knowing the rules and the codes of conduct of the Legal Practice Council, and also in knowing the Act and how certain things should be applied in the Act. So they already are assisting us in making sure that the objectives of the Council are met. And they also, I just skipped my mind what I wanted to say with regards to them.
About the law schools and the
Yes,
role
yes,
that
yes.
they are not only playing now, but perhaps a way in which they could accelerate things.
Yes, yes, you just reminded me of what I wanted to say now. Yeah, they've also commented on the proposed minimum wages that we've sent out in the government gazette, and they also for the change, and they do raise concerns with regards to the profession itself and how candidate attorneys on what they are going through and on a daily basis, and also engage with the council in making sure that all the objectives of the council are met and they are dealt with. Even with regards to the minimum wages, they also participated in providing comments on the hardship and what candidate attorneys are going through now. So they do assist the council in implementing its objectives.
So finally, then, whichever way you look at it, and there is no determination yet on the exact timescale, but you were saying that there is an urgency as far as the LPC is concerned to implement this as quickly as possible, and I do understand that. Going forward, then, in the short term, how should law firms and legal practitioners be preparing to adapt smoothly to the inevitable changes?
At the moment, they shouldn't panic because we've been receiving some emails from other legal practitioners saying they will be letting go of their candidate attorneys because of this proposed minimum wage, because they won't be able to afford it. But it's not yet set. It's still in proposal stages. What we need from the law firms is to guide and also participate in providing comments to the council to ensure that when these changes come into play, they also not affected, but they gradually become in sync with what's coming. But we just need their support also to assist, and them to comment and also provide suggestions on how this minimum wages should be set, and what would they be comfortable in paying. But having a candidate attorney working for less than bare minimum, it's not something that the council is willing to continue to let it go through or happen in the current state, because most of them are suffering. And some, like you mentioned earlier, they're even leaving the profession because it's really tough to become an admitted attorney because of the hardship that they go through. So we just hope that they will bear with us and see that we are not the enemy in setting this, but the council is trying to promote and grow the profession as a whole.
And as you rightly said earlier, access to good legal representation is critical. And I would also add, Brian, that it is a pillar, it's a cornerstone of South Africa's democracy. So I hope after that conversation that you have a sense of where this process is right now. I'm hoping that we have allayed some of your concerns and some of your fears, and that we have given you some indication of where all of this is going to land. And as my guest, Brian Mhlongo, rightly says, the process still requires comment and criticism, I guess, as well, and participation in the process, because it's only through that process, which will be considered by the LPC, that an equitable and a fair dictate will come out of the whole process. So, Brian and Mhlongo, thank you very much indeed for what I hope was an edifying conversation for all of our webinar participants today. Thank you so much indeed. It's been a great pleasure doing this. And let me just remind you again that our monthly webinars come to you from LexisNexis, and it's our way of shining a spotlight on critical that are facing the legal fraternity in South Africa. So we'll do another one of these next month, and I think that it's very useful. Let me just remind you once again, just before I bid you farewell, that Lexis Library is an online resource that makes it easier for practitioners to stay ahead of legal amendments with our ever-evolving laws. That's a no-brainer. With updated legislation and case precedent, this tool is the one that you need to lighten your load. No more daunting research hours, no more falling behind on evolving legislation with Lexis Library. So thank you very much indeed, Brian. My thanks to you again, and I look forward to hosting another one of these sessions in the not too distant future. So goodbye to everybody, and thank you for watching us.
Thank you, everyone. Thank you, Jeremy.